My Lady, I appear on behalf of the Solicitor General in this case. My learned friend, Mr. Joyce, King's Counsel, assisted by my learned friend, Miss Tandy, appears on behalf of the offender, Valdo Calocane, who is now 32 years of age.
Yes.
This is an application made on behalf of the Solicitor General for leave to refer as unduly lenient concurrent hospital orders with restrictions imposed upon the offender for 3 offences of manslaughter and 3 offences of attempted murder.
Yes.
Unless it would assist the court, I don't propose to open the facts in any detail, but suffice to say that in the early hours of the 13th of June of last year, the offender went out in Nottingham armed with a number of knives, and over the course of about the next 90 minutes, he attacked and killed 2 students who were walking home. That's Barnaby Webber and Grace O'Malley Kumar. He unsuccessfully tried to break into a hostel for the vulnerable homeless, and he caused Ian Coates to stop the van that he was driving, killed him, and then stole his vehicle. He then drove to the city centre, where he deliberately drove the van at 3 pedestrians, Wayne Burkitt, who suffered severe brain injuries, Sharon Miller, and Marcin Gawronski. The court will be aware that in respect of the fatalities, the offender was originally charged with 3 offences of murder. However, having received psychiatric evidence, the prosecution accepted pleas in respect of manslaughter for those offences by reasons of diminished responsibility. This court knows, but I say it because others listening may not, that this court has no power to inquire into that decision to accept the manslaughter pleas.
Yes.
And the solicitor...
This is a reference against the sentences imposed on the basis that you say that they were unduly lenient, and that is the only question for us today. Ms. Hare, you will of course take whatever course you wish, but just equally so that everybody understands, we have obviously prepared carefully for today's hearing.
I understand.
We have read the papers, and also in terms of managing expectations, we do not intend to be giving judgment today. We will be reserving our judgment, and I hope that that helps everybody get through the next few hours and can see the way forward.
I'm very grateful for that indication, my lady. Can I briefly set out the submissions made on behalf of the Solicitor General? And of course the court, if it has any questions,
Yes,
will invite me to respond.
thank you.
The essential submission made on behalf of the Solicitor General is that the exceptional level of seriousness of the offences was such that the case required the imposition of a sentence with a penal element, an element of punishment. And in this case, that would be a sentence of life imprisonment with a Section 45A hospital and limitation direction, sometimes called a hybrid order.
Let's call it that for today's purposes.
I'm grateful.
Thank you.
I've made clear in the reference document submitted that no criticism is made of the learned judge in his approach to the sentencing process, which was in accordance with the guidelines, and in particular the guideline for diminished responsibility manslaughter. But there are 2 matters which the Solicitor General invites the court to consider. The first relates to the calculation of the minimum term. Everybody accepted, I think, in the court below that were there to be a prison sentence, it would have to be a sentence of life imprisonment. Accepting that the judge was entitled to accept the psychiatric evidence, which supported a finding that the offender's level of retained responsibility fell within the lower category within those guidelines. Nevertheless, it is the submission of the Solicitor General that there were aggravating features which should have resulted in an increase from the starting point of 7 years for a single offence. The learned judge made an upward adjustment to reflect totality, but did not make an upward adjustment, according to his sentencing remarks, to reflect the aggravating features which are set out in paragraph 79 of the reference document, namely the significant degree of planning and premeditation, the use of a weapon, not just the knife that was used to kill, but also the use of the vehicle which was used as a weapon.
He had 3 knives in his bag, is that right?
That's correct.
Yep.
And others were put at risk of harm by the offender's actions, not least when Mr. Coates' van was driven at members of the public, but also in respect of those within Sealyhurst House, which was that homeless hostel which the offender tried to gain access to. No uplift was made to reflect those features, the learned judge having accepted that the offences would not have been committed, planned or otherwise, due to the offender's psychosis. However, it is submitted that his culpability was not extinguished by his mental impairment, but only reduced or diminished. He knew what he was doing. He acted deliberately and with the intent to kill. And therefore, these factors, it's submitted, should have resulted in an upward adjustment, albeit from the lower starting point.
Shall we have a look at what the judge did in terms of the minimum term that he arrived at before
Yes.
the guilty plea?
Let's just turn to that, if I may. Forgive me. Yes, it's at, I don't know whether my lady's looking at the digital system, but it's at Y71.
Yes.
At the bottom of the page,
Yes.
starting at G.
Thank you.
He first of all indicated that he accepted that the level of personal responsibility retained by the offender was at the lower level.
Yes.
He then said if all other things were equal, the relevant sentence under the guideline would attract a starting point of 7 years, and the range, of course, for the lower level of responsibility is between 3 and 12 years imprisonment.
Yes.
He indicated that there would be a significant upward adjustment to take into account the number of victims involved and the 3 counts of attempted murder, so effectively totality, and that a life sentence would be appropriate with a long minimum term. He then made an upward adjustment to reflect totality to 30 years.
Used by a third for guilty plea and then another third to reflect
the time that he would
yes.
serve if such a sentence were imposed. And I don't take issue with the matters of calculation that are set out in that paragraph. He was obliged to make reductions to reflect the fact that the whole of the minimum term would be served rather than a proportion.
Yes.
So that's what the learned judge said about it. But it's submitted that a failure to make an adjustment to reflect the aggravating features which are set out in the reference document and reflect those that are set out in the manslaughter guidelines meant that the minimum term that he calculated and arrived at was too short. Now, that in itself, in a case like this, doesn't mean that the sentence is unduly lenient. But in order to determine whether a penal element is required, it was necessary for the court to properly assess the seriousness of the offending, taking into account not just the mitigating features, which principally address the offender's mental impairment, but also the aggravating features to do with the commission of the offences as well. So that's the first point made on behalf of the solicitor.
Thank you very much. It's very clear.
The second point, and perhaps the principal submission made on his behalf, it reflects the need for a penal element in this case. My lady will be more than familiar with the guidance set out in the guideline cases of Voles and Edwards. I've set out the relevant paragraphs, I hope, in the reference document at reference paragraphs 75 in respect of Voles and 77 in respect of Edwards. But there must be sound reasons, it is established, for departing from the usual course of imposing a sentence which includes a penal element, punishment. Now, in Voles, the Court of Appeal identified 4 factors that the court would ordinarily need to take into account when determining whether there were sound reasons for departure from that principle. Paragraph 75 of the reference document or paragraph 51 of the case itself. Firstly, the need for treatment. Secondly, the court had to consider the extent to which the offending was attributable to the offender's mental disorder. Thirdly, the need for punishment. And fourthly, the protection of the public and the release regime. Now, in this case, there was no dispute that the offender needed treatment for his mental health condition and that his offending was attributable to a substantial degree to his mental disorder. As to the fourth of those factors, the need for the public to be protected and the release regime, the court heard evidence from the doctors at the sentencing hearing.
Well, three of them.
From 3 of them, and in particular, I think Professor Blackwood, called on behalf of the prosecution, perhaps gave evidence in the most detail.
Yes.
If you want a reference, he begins his consideration of the competing release regimes at page Y96.
Thank you.
But ultimately, it was agreed, I think, between all 3 doctors that there was likely to be a lengthy period of treatment in hospital, whichever sentence was imposed. Indeed, the considered view, and of course the doctors don't have a crystal ball, but the considered view was that it was very possible that he may never be discharged.
It was more than that, wasn't it? Very likely.
Very likely, yes. They agreed that the test for release was different as between the 2 regimes, the hospital and restriction order on one side and the hybrid order on the other. But the parole board, in determining whether the offender ought to be released, would take a broader approach to risk without purely focusing on the medical need for detention. That's dealt with at the transcript at Y99. The parole board was likely to consider the psychiatric evidence in coming to that decision. The principal difference between the 2 regimes would be supervision, or the supervision regime within the community, if it ever got to that. The evidence was that the Section 3741 regime would be more responsive because the medical team in the community would be more likely to spot if the offender was failing to comply with his treatment. But the court was also referred to the guidance in Edwards, at paragraph 22 of that report, about the multi-agency approach to supervision in the community following release from prison under the supervision of probation for an offence, or offences of this nature anyway, which would include input by the mental health agencies. Professor Blackwood, and indeed I think Dr. McSweeney, were also concerned about the risk to others in prison were a hybrid order to be imposed and the offender to be transferred back to a prison following discharge from hospital. But it was acknowledged by both, I think, that the decision whether to transfer the offender from hospital to prison would involve the same kind of risk assessment that would need to be carried out were release into the community in contemplation. And it was also accepted that in the event of a relapse, an administrative return to hospital could be effected by the Secretary of State under, I think, Section 47 of the Act. And it also shouldn't be forgotten, of course, that the level of supervision in a prison would be much greater than the level of supervision within the community. Now, it has to be acknowledged on behalf of the Solicitor General that all of the doctors favoured the regime under Section 37 and 41, the hospital order with restrictions. But they also made clear in their evidence that their assessment did not include the need for punishment or a penal element, which was beyond their remit and was a matter for the sentencing judge. And therefore,
in a crude nutshell, they favoured the hospital with restriction order on the basis there would be greater protection for the public.
That's right. For the reasons that I've set out, that the supervision in the community would be more responsive and the risk to those in prison were he to be transferred to prison and the risk
Edwards,
of relapse.
Authority you've very rightly referred to on a number of occasions. The comment is made, isn't it, at paragraph 12 by Lady Justice Hallett, that the graver the offence and the greater the risk to the public, the greater the emphasis the judge must place upon the protection of the public.
That's absolutely
you
right.
take no issue with that?
Of course not.
Thank you.
So, just drawing the threads of what I've said so far together then, the submission is this, that whereas here the practical difference in the regimes is limited because a very lengthy custodial term would be warranted within the provisions of a life sentence were a Section 45 order to be imposed, and where the evidence is that due to the nature of the offender's illness, it's a treatment-resistant type of paranoid schizophrenia, then release from hospital under any regime is highly unlikely. And in those circumstances, it's submitted that the features identified by the doctors do not amount to sound reasons for departing from the usual course of imposing a sentence with a penal element in the exceptional circumstances of this case. I've made it, I hope, clear in the reference document that there's no attempt to criticise the sentencing judge's approach. He followed the available guidance, but the harm caused and the harm risked in this case to members of the public by the offender's crimes was extreme. There are no decided cases of a similar level of seriousness, and therefore the court is invited to consider whether, in the particular circumstances of this case, a penal element was required, and whether the sentencing judge erred in imposing the hospital order with restrictions that he did concurrently on each offence. I hope that's put the position clearly. I don't know whether the court has any questions.
Very well put, very clear. Very effectively done. Thank you very much indeed. Can I go back to your first submission?
Yes.
Just with one question before asking my lords whether either of them have any questions. This relates to the submission that there was an inadequate uplift to take account of the aggravating features that you've identified.
Yes.
Could I take you to Professor Blackwood's evidence
Yes.
in cross-examination at Y108?
Why? Sorry.
108, page 31 of 66. The transcript for the second day of the full hearing.
Yes, I have.
The 24th of January it was.
Yes, I have page Y108.
So Mr. Joyce asks Professor Blackwood, and in fact it starts at Y107, letter H, page 30, question. When it's put that there are aggravating features of planning and so on, as you've heard, we're actually talking, are we not, about one psychotic episode in which all these other events took place? Answer by Professor Blackwood, yes, all the features that were mentioned in terms of purchasing weapons, changing SIM cards, calling his brother, changing his shoes, discarding the hold-all, etc., all occur in the context of an active psychosis. Question, missing out the first three lines, which don't matter, it in fact comes down, does it not, to all this? To this, all those aggravating features that you say make it worse, or are said to make it worse, are in fact part of one psychotic episode of intense severity, and Professor Blackwood answers yes. Does that affect your submissions?
Well, I can't go behind the evidence that was called in the court below, and this court is bound by that evidence, and I have to accept that. I suppose there are 2 points to be made. The first is that even accepting that these were offences committed within the context of a psychotic episode, nevertheless, the impairment, though substantial, did not extinguish the culpability of the offender. And therefore, although the lower starting point of 7 years was taken, nevertheless, an upward adjustment was required, albeit perhaps not to the same extent as would be required if a higher starting point was taken, because the impairment was less.
Understood.
My lady has effectively dealt with the question of planning that was raised by the solicitor at the end of their document by quoting at the foot of page 30 and the top of page 31 from the transcript of my cross-examination of Dr. Blackwood. Those were the very lines I was going to address the court with in answer to the suggestion that has been made throughout the case as to the question of planning. What is plain is that any planning took place under the influence of the psychosis, and I'm going to, if necessary, go into a little detail as to that psychosis so we can see from the evidence of Dr. Blackwood, Professor Blackwood, just how grave it was. And I say that for these reasons. I don't imagine for a moment that the court hasn't carefully read the transcripts of all the three psychiatrists' evidence, Professor Blackwood, Dr. McSweeney, and also Dr. Mervis, the treating clinician at Ashworth Hospital. The effect, though, of that is that all agreed, and these are very important words, that but for the psychosis, these offences, none of them would have been committed. And that has to be seen in light of the evidence, again, dare I say, in cross-examination of Professor Blackwood, that in this particular case, this particular man had been suffering from paranoid schizophrenia since 2019. It was formally diagnosed in 2020. Again, the court will have seen reference to the various episodes in which the psychosis or outbreaks of his psychosis subject to paranoid schizophrenia afflicted him. And that's relevant for a number of reasons. First, there is no concoction here at all, because that seems to have been, at least at the time, part of the suggestion by some others. That is not right. There was no concoction. This was a man, as the court heard from all the evidence, who until he was stricken, and again the court will have seen the early part of my cross-examination of Professor Blackwood, he was stricken by this dreadful condition through absolutely no fault of his own. He didn't cause it to happen to him by taking drugs. He didn't cause it to happen to him by his behavior. He didn't cause it to happen to him by taking alcohol. It could, and this is the evidence, it could happen to 1 in 100 of us at any time without it being anyone's of our fault. This was a hard-working man who had put himself through university, perversely in a degree of engineering that contributed in no small part to the effect of the psychosis upon him. It did it in this way. He had studied radiophonics and the like, and he came to believe that he was being controlled by outside forces, and he hated it. And my lady will have seen, and my lords will have seen as well, the evidence of Professor Blackwood as to the effect upon him. He describes how he is afflicted by voices that control him, voices that he hates, voices that he can do nothing about. And that is part of the reason, as Dr. Mervis in his latest report says, he believes, he still doesn't fully believe that he's suffering from a mental illness, because he believes that those voices are real. Those voices he is still hearing. Those voices are gloating at the trouble they have got him into here, that they got him into back in Nottingham. And they are pleased at the result of the effect that they've had on him. That's the effect of Dr. Mervis's report.
So it's entirely legitimate, Mr. Joyce, to emphasise the gravity of the condition, and we hear what you say, but we are familiar with the medical evidence and the cross-examination. So if there's anything particular you think we might be missing, then by all means emphasise it. But I think there are two submissions against you that you could perhaps just encapsulate your response to.
Well, I've dealt with the one.
Yep.
I deal with the other in this sense. If, but for this condition, he would not have committed any of these offences, it is in my submission wrong. And it's not found to be other than wrong by the authorities to which you've been referred, including the last case, which Mr. Justice Turner was good enough to bring to our attention at first instance. It's wrong to say, in those circumstances, if the responsibility retained is at the very lowest end, bordering on being no responsibility through insanity, it actually comes to this. He is to be punished for being mentally ill. And that is wrong. Our submission really goes completely opposite, as you know, to the solicitor's submission. And our submission comes to this. They concede that the learned judge, and he had all the appropriate guidelines and cases brought to his attention. You can see from the sentencing remarks that he went through all those considerations carefully, steadily, sensibly, and unemotionally. You can see that he applied the law on the authorities fully, and he came to this conclusion. The conclusion that the proper sentence was a hospital order under Section 37, together with a restriction under Section 41.
Having read the submissions over the 2 days, is it fair to say that neither you nor prosecuting counsel below was suggesting that either option was, if I can use the phrase, out of bounds? The judge had a choice to make, but nobody was saying the other order, the one that that person was not going for, was out of bounds.
My lady, in our original defence note, we said that the prosecution were absolutely wrong and it could only be a Section 37,
Right.
Section 41.
What about the prosecution?
Oh, they were saying it should be a hybrid order.
I know, but were they saying that anything else was out of bounds?
Yes.
Right. That's different. I'm drawing a distinction
Of course.
between saying we suggest that this order, a hybrid order, is appropriate, more appropriate, obviously more appropriate. Was it being said that a hospital with restrictions order was out of bounds, completely wrong as a matter of principle or fact?
No, it was being saying it was preferable that it should be a hybrid order.
Well, that's how I read the submission.
Yes.
So I'm drawing a distinction between saying, on the one hand, this is the better, preferable, right course of action,
Yes?
to saying that something is completely out of bounds and wrong. Nobody was saying either option was out of bounds,
No.
as I read it.
No, not in that sense, no.
Thank you. I interrupted you, Mr. Joyce.
No, it's quite all right. I suppose in the simplest possible language, what we on behalf of Mr. Calocane are saying is this. On all the evidence, he is very likely to spend the remainder of his days in a secure, or to a degree secure, mental hospital for what happened in Nottingham on that dreadful day. It follows from that, and when one reads the evidence from the latest statement of Dr. Mervis, that whatever the case, he's going to be there receiving treatment for a long time. It doesn't seem as if there is a particularly active response, if I can say that, to the latest drug therapy yet. And it doesn't seem as if yet, according to Dr. Mervis, he has been persuaded, for want of a better word, that he is ill rather than afflicted by these voices and outside controllers. The doctors were right. He's never likely to see the light of day again. And if that's right, and if that's the effect of the sentence that Mr. Justice Turner passed upon him, the question we pose, if you like in layman's language, is how can that possibly be an unduly lenient sentence in anyone's parlance? Lady, may I finish like this, please? We have tried to help by setting out in our 8-page defence document all the matters that we relied upon and rely upon. To repeat them now would be mere repetition, knowing that you've all read them. Since you're going to reserve judgment in this case, can we invite you to read them again, but particularly to read again the evidence of the 3 psychiatrists, because they make it absolutely plain that they were in full agreement, and they make it absolutely plain that this defendant's moral culpability, if I can so describe it, was at the very bottom end of the scale because of the degree of the illness in which he is still grievously suffering. And you can see part of that in one of the replies that Professor Blackwood gave to me, that he wasn't at all surprised that Mr. Calocane took months before he even trusted us. Apart from going through the documents, I'd be repeating myself.
No, thank you, Mr. Joyce. Ms. Dear.
There's nothing further that I'd want to add unless the court has any questions of me.
No. Thank all counsel involved for their very helpful submissions. What we will do now is rise shortly just to consider where we go next. As I've indicated, we will be reserving judgment, but I think we should have a final discussion before we come back and confirm that. So for the members, everybody in public and online, we're just going to rise now for 5 minutes or so, and then we'll come back into court and tell you what our next steps will be.
Thank you.
Thank you. Thank you, Miss Dear, Mr. Joyce. This has been a short but a very effective hearing. We are going to reserve our decision and our judgment, but obviously we recognise how extremely distressing this case is for all concerned. What we hope to be in a position to do is to hand down our judgment within 7 days or so. We will keep in touch with the parties on dates and times. What we anticipate doing is producing a written judgment, which we will hand down, accompanied by a short oral summary from the court. There would, of course, be a press summary in the normal way, but we don't at the moment intend to hand down an embargo draft in advance for correction or anything else. So it'll be an in-court hearing for all concerned. Are there any practical difficulties? And if you'd like a moment to speak to those behind you, please do so. Ms. Dear,
I
are you in
was
difficulties?
asked, in fact, before my lady made those comments, to ask for some sort of an embargoed copy so that the families could at least be given an indication,
Yes,
even in headline form,
yes.
of what the outcome was likely
Well,
to be.
we understand the issues there, and we'll take that away, if I can put it that way, Miss Dear, and see where we go from it. But I understand the request. And there are obviously lots of considerations involved in that, but we will bear that very much in mind.
I'm very grateful.
In terms of practicalities and availability, of course you are both released if necessary on the next occasion, but I imagine that you would like to be here if possible, and we would like to accommodate that if possible. Perhaps again we can liaise with you through the normal channels as to dates and availabilities, and of course for families and anybody else attending, if there are any particular difficulties there, please contact the court and let us know.
Certainly.
We will try and come up with a date for you as quickly as we can. As I say, we do want to limit, if that is possible, as far as possible, the acute anxieties and distress involved in this very, very tragic case.
Yes, the only observation I would make is that, with respect, the embargo should be preserved until such time as the judgment is given.
Well, we will take the matters forward. Embargoes obviously are there to be complied with, and they have carry very grave consequences if there is a breach. But we've heard what Ms. Dear has to say, and we'll think hard about how best to deal with the situation. I think we understand the arguments on both sides.
Yes.
Thank you all for your attendance. Thank you for the careful preparation of the papers, which has facilitated, as I said, a short but effective hearing.
Thank you.
Thank you all very much indeed.